Welcome back to The Big Picture. I am Penny Wolfgang in for Phil Arno, welcoming back Erie County District Attorney John Flynn and continuing our conversation at the moment about the proposals to legalize marijuana. And what we were talking about before we went on the air was this issue of the danger of a proposed law that would prevent the police officers, law enforcement, from using the smell of marijuana as probable cause to search a car. And it ties in with this, legalizing. It's legal to have marijuana. Mm-hmm. I mean, that's the thinking. It's legal to have it. So why would you be able to stop somebody? And what is the problem? What's the good of it and what's the bad of it?
Well, it dovetails into the other main concern that I have about the legalization of marijuana, and that is the safety of our roads. So put aside all the issues that are in play with regard to road safety, just per se road safety. One of the things that I see that is put into this bill, and the writers of the bill, from my understanding, are adamant about putting it in there, is the fact that right now, if a police officer pulls a vehicle over for whatever, a broken taillight, speeding, doesn't matter. They pull a vehicle over, they initiate a normal, legal traffic stop. When the officer gets out of the car and approaches the vehicle, when the officer has the person roll the window down to get the license and registration, if that officer smells marijuana in the car, that gives the officer probable cause to search the car automatically. The language that is in the new marijuana legislation is going to outlaw that. It's going to say that the officer no longer now has probable cause to search that car. And the problem with that proposed language is twofold. One, Judge, from your days on the bench, and I can't even tell you how many illegal weapons we find in these searches.
Yes.
And again, what's ironic here is that I understand what the drafters of the legislation are getting at. They're getting at the fact that overwhelmingly the numbers show that African Americans are being arrested for marijuana violations than Caucasians. It's true. They're right about that. And studies have shown that both Caucasians and African Americans use marijuana to the same degree. So obviously, if whites and blacks use marijuana to the same degree, but African Americans are getting arrested more, we got a problem. And I recognize that. I'm all for that. But the problem is going to be is that these weapons, illegal weapons that we take off the streets, they're being taken off the streets on the east side of Buffalo. We're not taking guns out of Williamsville. We're not taking guns out of Orchard Park. So the communities that are going to be hurt by this proposed law are the very communities the law is trying to help. And that's my concern. I want to keep the African American communities in the city of Buffalo safe. I want the senior citizens to be able to walk to the store. I want kids to be able to walk to school without getting shot. So in order to do that, I need to get the guns off the street. This law is going to keep guns on the street, and that's my main concern.
And as you pointed out, there's numerous cases where the guns are found in the car, and as you said, it's going to make it very difficult if that doesn't go into effect.
In addition to guns, Judge, other illegal narcotics, opioids, cocaine, heroin, fentanyl. I mean, all of the serious narcotic drugs that we are fighting every day, sometimes in these searches, when you smell marijuana, other drugs are in the car. that we're now able to take off the streets and again, save people's lives.
And especially since we've been making such, I say we because both of us are on the Erie County Opiate Task Force, they've been making such progress with the opiates, and I know you statistically there's been so many less deaths, less abuse, so it would be a shame if that does happen. We were talking before about just before I forget, on the child abuse and the clergy. Will there be a possibility of prosecuting, and people are, I think, asking this all the time, the bishop, the higher up people who were involved allegedly with the cover-ups or didn't do what their job required, or what they didn't report, and so forth? Would there be a possibility of prosecuting them?
There's always a
legally?
possibility. The problem is that the administrators are still subject to the same statute of limitation issues that the victims are, that the victims face with regard to the perpetrators of the sexual act to begin with. So, for example, there are only a handful of crimes that you could potentially charge an administrator with, either a bishop, auxiliary bishop, a head pastor, whoever. There's hindering prosecution. Now, the hindering prosecution charge, that mirrors the actual charge that you tried to hinder.
Right.
So if you tried to hinder a sexual assault charge that only had a 5-year statute of limitations, you're still subject to the same 5 years. If you have an endangering the welfare of a child charge, as you know, unfortunately, endangering the welfare of a child is only a misdemeanor. And so that you only get a 2-year statute of limitations there. So the reality is that the administrators who allegedly covered this up, the statute of limitations has gone by years ago.
You're not going to bring up those two favorite words of everybody, obstructing justice?
Well, again, obstructing justice
come on.
is a very unique charge, and difficult charge
in the
to prove.
penal law too.
In the penal law,
especially in state penal law.
You have a much better chance of a hindering prosecution charge than you do an obstruction of justice charge.
We only have a little while, but I wanted to bring up another new law that has been in the news a lot, especially with the courts, bail reform.
Oh, yeah.
And it's changed so much about the way defendants are treated in the criminal justice system that I don't think people are aware of it, but it's like a sea change.
Total sea change. You're going to have a major difference on January 1st. So this is one of the laws I was talking about before, where the normal procedure has taken place there. They passed a law this year, the governor signed it, but it's not going to take effect until 6 months later. So it'll take effect on January 1st of 2020, and basically the judges have no discretion now to give bail in misdemeanors and non-violent felonies. So all misdemeanors and all non-violent felonies, the individuals who are facing charges are going to be let out. They're let out. And so
when we say without bail, there's going to be certain restrictions instead of bail, instead of money bail. Maybe we should.
Cash bail's gone.
Cash
so
bail.
There's still going to be a increased emphasis now on pretrial services. So individuals from the county are now going to be responsible for calling people up, writing them letters, reminding them about their next court date. In some instances, you can put an ankle monitor on them, an ankle bracelet to keep track of where they are. But the practice of cash bail for misdemeanors and nonviolent felonies is virtually gone on January 1st.
And one of the reasons that people are so worried about it is in instances like of violence, like whether it would apply where you get called to a domestic violence situation, for example, or an ongoing assault, you know, where two people are fighting, and instead of taking one away to jail, which would usually happen, they're going to be saying you have to give them an appearance ticket. And I think the public should be concerned about their safety.
Well, yeah, that was one of my main concerns. I mean, I was all for bail reform. Quite frankly, I've been practicing it myself for the past year here in Buffalo, where I've told my assistant DAs, don't ask for cash bail on a misdemeanor or nonviolent felony unless there is a darn good reason. A darn good reason being if it's a domestic violence situation. And believe it or not, there are a lot of DV cases that are misdemeanors. And so if it's a domestic violence situation where the person has violated a court order of protection to stay away from the victim, and they don't, if the person has missed numerous court dates, that's a reason. Unfortunately, the new law didn't give me any reasons now, so I'm stuck with it.
Yeah, I just think that sometimes there's not enough concern, and I'm sure you agree with me, for the victims and for the people and for the law-abiding citizens as there are in some of these new laws, which you said you agree with to some extent, but they can't be carried that far, like the examples that we're giving.
Yeah, I mean, everyone in the criminal justice system needs to have their voice heard, and certainly defendants need their voices heard, but like you said, so do the victims of crime.
And we were talking briefly about expunging the records of people. This seems to be, in the marijuana law particularly, a major thrust of the legislation, that they want to have expunged the records so that people don't have to carry records with them. I don't know how much that applies or how many cases that would be for minor crimes, for possession, like they used to be for possession of marijuana, for example.
I mean, there's going to be some, obviously, but you know, that's not going to be that big a deal. We can do that fairly easily. Matter of fact, I'm doing that already to a certain extent. Even before the bill passes here, I've taken it upon myself to dismiss and to get rid of the warrants on all old bench warrant cases for just small level marijuana violations. I've done it in the Buffalo City Court, I've done it in Amherst, I've done it in Cheektowaga, and I'm going to go town by town and do that all across Erie County.
Well, thank you. Thank you, District Attorney John Flynn, so much for joining us on The Big Picture. I'm Penny Wolfgang, and thanks for watching WBBZ-TV.